Okay. Excuse me, you guys, we're recording and we're live. Hello, we're recording and we're live.
Oh, never mind.
Judge Sharp, good morning, Your Honor.
Good morning. How are you?
How are you? Good morning yourself.
Good.
Judge Sharp, good morning, Your Honor.
Good morning. How are you?
How are you?
Uh-oh. Good. Is there any reason why this is? Yes. Is it removed now? Can you hear it? Okay. Madam Clerk, this one that was, this one that was just handed to me, is this one retained counsel or is this?
No, that's the one that the jail is supposed to dial into us.
Okay, I'm gonna set this one to the side.
Yes.
Okay.
That was retained, and we also have number 9 is retained. What's his name? Jamal Colbert.
DDC? Is it DDC? DDC?
Yes,
Can you hear me?
Yes, Your Honor.
Can I have Mr. Moore, please?
Copy that, Your Honor.
Stephen Moore. Where's it, Darnell?
Middle name.
Darnell. Okay, Stephen. Counsel is present, right? Retained counsel on Moore?
Ready, Your Honor?
Okay, thank you. Mr. Moore,
Yes, ma'am.
can you state your name for the record, please? Your entire name, including your middle name.
Darnell Moore.
Mr. Moore, you have some outstanding tickets that you have not addressed. So we're going to address those first. Those are misdemeanors. You have a driving while license not valid or improper license. And you have, and that is going to be ticket number, actually SP 1209626 excuse me, start all over. SP 1209691. And you also have SP 1209692, and that was no insurance. Both of these are misdemeanors. They carry up to 93 days in jail and or a $500 fine. I am going to counsel enter a not guilty plea for him in these matters. And I am going to set these for hearing. You got a pretrial date of 1/12/2024. You have the right to remain silent. Anything you say can and will be used against you. Do you understand that?
Yes, ma'am.
And on this, you will have a personal bond on both of these matters. Okay, as for your felony case, you have counsel present here for that. You are being charged with these are not the details of sure.
Thank you. Christina McPhail, Scottsdale, P 70739,
Mhm.
appearing on behalf of the city of Baltimore.
Thank you. Counsel, how do you wish to proceed in this matter?
Your Honor, I was going to waive the formal reading of the charges. My client is well aware of them, but I believe he is, but I did have the opportunity to speak with him physically at the detention center,
Mhm.
and I don't believe he was there for all the charges, so I am not gonna waive its formal reading, Your Honor. If the court could oblige us and go ahead and provide that to the defendant.
Okay, as soon as I can find it. Interesting, because I don't see. Where's the complaint? Yeah. Count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons carrying concealed. Count 4, assault with a dangerous weapon, felonious assault. Count 5, weapons felony firearm. Count 6, weapons felony firearm. Count 7, weapons felony firearm.
Thank you, Your Honor. Thank you. My client said he-
All right, I will enter a not guilty plea and set this for the next probable cause hearing, probable cause conference date, which is going to be 12/15, and a preliminary exam date of 12/27. Bond conditions will be no guns, no weapons of any kind, no pepper spray, no taser, no brass knuckles, or any type of instrument that can be used as a weapon as it relates to bonds. I'll hear from the people first. Thank you.
Good morning, Your Honor. Samuel, nice to see you.
Good to see you.
Samuel A. Wagner, P-23-157 on behalf of the people. Your Honor, this is obviously a very salted matter. On December 4th, 2023, at approximately 1:24 a.m., the police were called to the address on Cadillac Square, Druck Street, with regard to the shooting. Upon their arrival, they talked to the complainant in this matter, who stated that she had come to the apartment to do her laundry. That her friend, the defendant, was going to let her do her laundry, And that while they were waiting for the laundry, they were drinking. He then has a pole in his apartment, which he got on the pole and was dancing on the pole. He then jumped on the pole and kicked her in the face. With that, he got upset and they started arguing, and he went in the bedroom and got a gun. With that gun, she said, she went downstairs, got her laundry, said, I'm ready to leave. She gets in her car, she goes. He has to open a gate for her to leave. And as he opens the gate, he goes to the passenger side and he spits on her. So she gets upset, parks car, gets out of the car, and they have a fight. She pulls him down, I think by her hair, on the ground. He becomes obviously more upset. She gets in her car and leaves. And the defendant follows her. Well, before she leaves, the defendant shoots at her multiple times with a pistol, striking her in the hand. She then goes to a 7-Eleven store and asks for someone to call 911. The defendant was back at his apartment building. She was transported to the hospital for treatment in stable condition. The police went to the apartment, they found the defendant in the hallway of the apartment building, and they arrested him. Ultimately, and I'm not going to go through the whole story, Judge, but ultimately they had a search warrant for his apartment. They had a search warrant for 10B, I'm not sure. Yeah, for apartment 10B as well, because they saw on video that he went into a separate apartment that was empty, but he had a key. And in that apartment, they found the pistol that this man had that he used to shoot at and wound the defendant. There also is additional video from the Rock Station video, Your Honor, of the incident and of the shooting. So there is evidence that is very instructive of the defendant's actions against the complainant. Your Honor, very serious matter. Shooting a gun, shooting at someone with intent to murder them, shooting in public like that is a danger not only to this victim, to the family. We're going to ask for $150,000 cash bond. If he's able to post bond, we're going to ask for a GPS tether with home arrest. Thank you.
Thank you.
Thank you, Your Honor. Briefly, we're just now in receipt of the report, investigative report to actually be able to review it. Your Honor, my client does have a viable defense. One, the court should be advised that the incident took place at his domicile, his apartment, and he's also the superintendent there. So it would be the normal course of business for him to have access to the other apartments and so forth. He's resided there for 2 years. My client also serves security there. So he's specially trained, has multiple certifications in home improvement and security. He is a CPO holder. I'm not sure the status of that CPO currently at the time of this incident. But again, his handle firearms. I believe that he attempted to want to murder someone, he actually showed his marksmanship type shooting skills. But nonetheless, I think the facts of this incident would play out. My client is stayed there to be able to talk to the police. I believe he made a statement to the officers while present at his place of employment and residence. He's got a flight. He cooperated with officers' commands upon being arrested. In this case, he was actually detained for the 72-hour period, let go, and then once formal charges were issued, they were able to arrest him again at a place where he indicated that typically he would be, so he wasn't running from them, he was cooperative with the process. With respect to any of the other facts, Your Honor, again, those facts they are in dispute. We would just again allow the process to play out for that. With regards to the arraignment and issue of bond, again, he's lived at this residence for 2 years, has been in that employment for 2 years as the superintendent for the building and security without issue. Prior to that, he's an individual, 29 years old, a city dweller, a graduate of Clinton Township High School, again with the multiple certifications from different organizations, schools, and so forth. He comes from really good family, from the stock, which is exactly how I know him from more. They retained counsel right away upon the incident. Does us being here, he's likely to appear in court, show up to court. Again, there are some facts and disputes that will have to play out through the process here. And we would ask the court if there was going to be $150,000 bond, that the court would consider 10% reduction or lower that bond so that he can actually be available, work with his counsel to address these very, very serious charges. He is a father to a 2-year-old who he is a provider for. He pays child support on time. His court orders to indicate that there's no prior history for this individual other than what the court pointed out as those misdemeanor matters. He doesn't have that type of felony history or violent history on his record. Again, Your Honor, the court would consider at least a 10% provision. We won't object if there's a GPS tether needed because of the severity of the crime, but that at least be within reason for him to be able to address these matters, help his defense in this case. There's video obviously from the workplace that we are not yet in receipt of. We anticipate we would be able to get that directly from the employer or from the people to be able to review that. There may be some type of exonerating evidence there. Again, that has yet to be seen. But I don't think that, I think he's a strong community member and he has strong employment history and comes from a good family with a good reputation here in the city as well. And we would ask that we find the more reasonable for the people as, again, we will reject GPS tether. That's what the court believes is in the best interest of the community and safety for our person. And of course, respectively, he'll abide by no contact with the victim and any other situation that the court indicates.
Yes.
He does not have a CPL license. Apparently doesn't ever had my records. But the incident, Your Honor, as we stated, is on video.
Yes,
He
I'm
also
aware of that.
went ahead and took the license plate off of her car after he shot her. And he took that license plate, which was subsequently found in the apartment along with other magazines and things for the gun that he had, Your Honor. So obviously he was trying to, I think, hide himself and not let her be able to be searched or found. But whatever the reason is, shooting someone is the worst thing you can do, I think, to a human being. She's lucky that he is a bad shot or she would be dead. So, Your Honor, you don't just shoot someone multiple times and then think that I'm not trying to kill her. That's what I believe he did, and we're asking for the $150,000 cash and GPS tether to able to pull spot. Thank you.
So yes, as a part of the bond conditions, Mr. Moore is to refrain from Malika Williams. Did you hear me, Mr. Moore? You have to refrain from, if in fact you're able to post bond during the pendency of this matter, you are to stay away from Malika Williams at the 21210 Patton Street address in Detroit. Do you understand that? In looking at what's before me, the court takes guns and shooting at someone else very seriously. He allegedly kicked Miss Williams in the face, causing her nose to bleed. Video footage shows Mr. Moore running from an apartment building with a gun, a handgun, and shooting someone multiple times is very serious. By clear and convincing evidence, I think that he is a danger to others, and the court is going to impose a $150,000 cash surety bond with house arrest. Is this an affordable bond or not affordable bond?
This is not an affordable bond. He works as a place of residence, assuming that he keeps his housing and employment there, because that's a condition, obviously, he works there. but he doesn't earn that kind of money. And
So,
he's under child support and, joint parenting.
so I will set this for a bond redetermination hearing in front of the chief judge, for Monday, December 11th.
Thank you, Your Honor, we do appreciate that.
Thank you.
Monday,
9 a.m. Thank you. Thank you.
Judge, did we get
The
dates?
other dates.
Yes, the initial probable cause, hearing date is, 12/15. And the preliminary examination date is 12/27. Thank you. You as well.
For your whole life?
Justin Benjamin McKinney.
Good morning.
Good morning.
Camera on the women's side is busy.
Pardon me.
No, I think the camera on the women's side is busy. We're not able to get them.
Okay, let's see. But,
Oh, that's.
yeah.
That one? Nah, she's back.
Yeah, you can. I'll just let you know they have to be patient with it.
Can they give it after the fact? Or do they have to? Let them know they, yeah. Okay. I'm just gonna set these to the side. Thank you. And the next retained matter is Jamal Colbert. Mr. Colbert?
Come on, Cole. Come on, Bo. Step on the black line.
I'm gonna just keep it
Yeah,
together.
please. Okay. I gotta get it. This is this one. I'm sorry.
It's okay.
I'll get it.
We'll put everything to the side.
Yes. No,
And then put everything to the side and have it in stack for you.
Please. Thank you. Please state your full name for the record, including your middle name.
On to real Colbert.
Mr. Colbert, you are here for, you're being charged with assault with a dangerous weapon, count 1, count 2, assault with a dangerous weapon, felonious assault, count 3, assault with a dangerous weapon, count 4, driving reckless. Your counsel is here in the courtroom. Counsel, please state your appearance.
Good morning, Edward Taylor, T571166.
How would you like to proceed?
And you waive the formal reading of information.
All right, so your probable cause conference date will be December 15th, 2023. Your preliminary examination date will be December 27th, 2023.
May I address bond?
Yes, 1 second. Yes, go ahead and address bond, and I will give bond conditions after you're done.
Your Honor, this is Mr. Colbert's first. Live resident in Detroit. He has, good community ties.
People, state your appearance, please.
Samuel A. Ragland, 157 on behalf of the people, Your Honor. And it's a very salted matter. The complainant was driving down M39 when the car in front of him pulled in front of him, and then tried to run into him to barricade. Not once, but at least twice. The complainant then got off of the freeway, and they followed him. He followed him off the freeway to the corner, probably. That's my assumption. And then when he got back on the freeway, the defendant couldn't get on the way that the complainant did. The defendant was picked up, total lineup, Your Honor. He had the license plate of the vehicle that was trying to run him into the wall. The license plate went to a vehicle that was owned by the defendant. It was the one that he was driving at the time. So they were able to find cell phone information where the defendant was at the time of this incident, which was on M39. They were able to produce the block system of cameras capable of reading license plates that the defendant, they could see the defendant's vehicle was at M39 at the time of the alleged assault. They also were able to observe use a search engine that determined what the conducting preliminary mapping of the defendant and his car. So there's not too much question about what happened, that this defendant was responsible for it. So, Your Honor, we were going to be asking for a $10,000, 10% bond, GPS tether with home arrest.
Counsel, does your client work?
He does, Your Honor.
Where does he work?
Mr. Goldberg, could you tell us where you work in your hours, please?
Hear you?
Where do you work in your hours?
I work at AAA.
What are your hours and what day?
Monday, Tuesday, Wednesday, Friday, Saturday, 6 a.m. to roughly around 3:30 p.m.
What do you do there?
Towing.
I take it that Mr. Colbert did not know the complainant.
I don't believe so, Your Honor.
They don't know each other.
No, Your Honor.
Does he have any, is there any prior criminal history here? No.
No, Your Honor.
So this court is going to impose a $10,000, 10% cash bond, in addition to a GPS tether, allowing him to go to and from work.
Thank you, Your Honor.
Thank you. You as well.
Next man.
Say it full name again, bro.
Justin Benjamin McKinney.
I am so sorry. What you need for me to do?
Am I bothering you?
Mm-mm. What you need for me to do?
Just write the mind. You don't have to do
I forgot to call.
all this. It's,
Shoot.
yeah, you don't have to write on every sheet. You can
Okay.
fill that in later, okay? Just on the first one.
Which one is this one? This is Cobra, so I just did, so it's 10,000, 10%. So what do you want me
2,010%, so
Yeah.
you could circle the 10%.
to and do 10,000?
Mhm. And if you have extra bond conditions like GPS, you can just screw it in there. And then
What else you need? You
This
can keep
is-
doing it afterwards if you want, if this makes it easier for you.
if this, this is, I mean, we just need the bond
Okay.
amount and extra conditions. And if you want to do the sign it later, you can do that later.
Yeah.
And then, and this is usually how they start off.
Yeah. I don't know.
They usually
Nervous.
they read the way the reading that would say time or read the charge.
I'm skipping it all. What's your name, sir?
Justin Benjamin McKinney.
All right, calling case number 23044564001, the People versus Justin McKinney. State your full name, including your middle name.
Justin Benjamin McKinney.
All right. All right, Mr. McKinney, you are here for count 1, domestic violence. Your attorney is here on your behalf. Counsel, state your appearance.
Madam Marat, P3665, I'm Mr. Justin McKinney, judge who waived the reading, Mr. McKinney stands reading for the findings, right?
All right, I'm going to give you a probable cause, no, I'm sorry, a pretrial date of December 8th, 2023 in front of Judge Garrett. All right, bond conditions, you are to refrain from having any contact against the complainant.
Your Honor, I'm so sorry if I may.
Sure.
I think the date you gave us was December 8th. I think it might-
That is correct. You're correct about that. That's what's actually on here. Madam Clerk? Sure. Sorry. I have a pretrial date of December 8th, and obviously that can't be correct.
That's the judge here.
That's today.
That's correct.
Oh my goodness. This is somewhere.
12/12, December 12th, 2023 in front of Judge Garrett. That'll be your next court date. Interestingly enough, this is interesting. Madam Clerk, I just want to say that what is missing?
That's it, right? The investigative report, and that's all that we have.
I don't have the complainant's information on here.
I'm sorry for the.
The complainant's information. I don't have her information.
Oh, the,
You understand? Unless I'm missing something, I don't see that. There. So, Mr. McKinney, in terms of your bond condition, you are to refrain from having any direct or indirect contact with Alexis Bailey. That means no phone conversation, no in person, no notes, no third parties are to be used to try to communicate with Ms. Bailey. So in terms of bond counsel, what are you requesting the people?
Judge, good morning. Privileged to see you this morning,
Yes,
Stevens,
ma'am.
on behalf of the people, P71917. Just to expedite this process, Judge,
Mhm.
it appears as though this is a reissue. Believe it or not, it's a 21 misdemeanor EV. This defendant was arraigned on this matter, this incident date in May of last year. The complaining witness failed to appear earlier this year at exam. It was dismissed, and it appears as though it's a reissue. At the arraignment in 2022 in May, I believe it was the Honorable Magistrate lawyer gave a $10,000 personal bond. We would just be asking for that $10,000 personal to be imposed.
No objection.
All right, so there will be a $10,000 personal bond in this matter. Thank you, Mr. McKinney. You can step aside. Thank you.
Face the camera, say your full name.
Mario McCann.
1 second.
My little brother.
Here. What's your name?
Say it again.
Mario McCann.
Okay, calling case number 230-456-3501, the people versus, is it Kawan McCann? I can't hear you. I think you're muted, DDC.
There you go, y'all. What's the name?
Okay.
Mario McCann.
All right, so you're here today, sir, for count 1 assault or assault and battery. You have counsel present here on your behalf, counsel. Your appearance.
Ramsey-Heath, 3665 on behalf of Mr. Kamari on behalf of waive the reading. Mr. McCann stands as new judge has been advised of his constitutional right.
All right, so there's going to be a pretrial date set for February the 12th, 2024 in this matter in front of Judge Bryant. Let's address the issue of bond counsel.
Thank you, Your Honor. This is not a case that happened in September of this year. Allegedly, because he was being escorted, he was, I guess, creating some type of disturbance in the school that he was going to. He didn't like the fact he was being escorted out, ends up throwing a punch at the security officer. Judge, it's charged as a misdemeanor, 93 days. If Your Honor already handled the no contact, at least through the pendency of this, we're not going to object to a personal bond here.
Judge, personal bond's appropriate, no priors here, no pending matters, no objection, no contact with complaining witness. My client is stable residence, has a life resident here in the city of Detroit, no case history, no criminal history, just started working at Applebee's. I'm asking for that personal bond.
Okay, so the complaint Nehemiah Thomas. So
We would be asking, Your Honor, just no contact if he's working and not attending the school at this point, just no contact with the individual or the school, at least through the pendency of this case.
No objection.
Okay. So there's gonna be a personal bond. Did you just say personal bond in this matter?
Yeah, personal bond in the amount of either $5,000 or $10,000, Judge.
Personal bond in the amount of $5,000. You're not to have any contact with the complainant in this matter. And also in terms of staying away from, what did you, the people are requesting?
I'm sorry, Judge. Yeah, we were just requesting no contact with the complaint in this matter or the address, which is the school. It's that, I believe it's the 9100 Gratiot Avenue.
And the 9100 Gratiot address.
That's correct.
Okay, thank you. You can step aside.
I don't have a problem with him asking a question. Can we call him back?
Can we have him to come back, please? He has a question. It may be addressed for his counsel.
Yes, so he said that he was gonna drop the charge because he wanted me to re-roll back in school.
Anything you say can and will be used against you, and your counsel is advising you not to say anything. And so you may want to get in touch with your counsel after you are released to have that discussion.
Thank you, Your Honor. I have nothing further.
Yeah, thank you. I have to do this. Yeah, right.
I'm sorry.
State your name for the record, please.
Emil Upchurch.
Emil Upchurch. Say Emil Upchurch?
Yes, ma'am.
I don't think that. I don't think I have Emil Upchurch.
Oh, I'm sorry. I didn't.
You had it. All right, so you have some misdemeanor matters that you have failed to address in terms of a ticket. Calling case number U 92085512. This was let's see. The ticket is not here. A narcotic drug violation. So I'm going to set aside the warrant and enter a not guilty plea on your behalf. Your pretrial date will be January 11th, 2024, in front of Judge Jones. You have the right to remain silent. Anything you say can or will be used against you. If you can't afford an attorney, the court will give you an attorney. Going to your felony matter. This one is okay, you have a domestic violence issue. Calling case number
Corner of that register act. What you holding in your hand? It's the case number 05.
Right, I'm just getting ready to call.
Okay.
Calling 05-057-34001. The People versus Emil Upchurch. Again, state your full name for the record.
Email Upchurch.
Okay. You have counsel here present in the courtroom, counsel, if you state your appearance.
Sorry. Driver on P 3665, on behalf of Mr. Upchurch, we waive the formal reading. Mr. Upchurch stands to you. He's been advised of his rights.
All right, a not guilty plea has been entered on your behalf, and we need a correct court date, Madam Clerk.
December 12th.
December 12th. Okay, your next date will be December 12th in front of Judge Garrett, 2023. All right, as to the issue of bond, I will address bond conditions after. I will hear from the people.
Thanks, Judge. It is a 2005 matter. It's being charged as a misdemeanor, but for the fact this is approximately 8 years old, I think I may have treated it differently in terms of how I approached bond. The defendant at the time was on probation. He was on probation for a controlled substance offense. He was only on probation as a direct result of multiple violations, which that probation extended to 2008. Ironically, this defendant just resolved a failure to pay felony matter over in Frank Murphy yesterday. So we had a defendant who subsequently was getting involved in things following this incident. However, with all of that being said, I haven't found any assaultive type allegations and or convictions since this offense. And as a direct result of that, I'm not going to be objecting to a personal bond at this point.
There's no assault history here. That child support matter was dismissed because it's last year's payment. Personal bond should be appropriate. I'd ask the court for that. With regard to the complainant witness, this is a former girlfriend. This was a long time ago. He does indicate that they're still close. I think no assault contact might be appropriate here, but I believe that in the court's discretion on this personal bond.
Okay, in terms of bond conditions, Mr. Upchurch, you are to have no contact with the complainant. That means no phone calls, no direct contact, indirect contact, no social media, nothing. And the court is going to impose a personal bond. You can step aside.
We would just be asking if
Mr. Donovan, Your Honor.
Oh, I'm sorry, excuse me. $5,000 personal, thank you.
Thank you, Your Honor.
Thank you.
Face the camera, say your full name.
Marquise Criego.
Okay. Marquise. All right, calling case number 23060333601, the People versus Marquise Holcomb.
Samuel E. Reagan for the people, Your Honor.
Driver on P 3665, on behalf of Mr. Marquise Holcomb, we waive formal reading. Mr. Holcomb stands to you. He's been advised of his rights.
All right, so a not guilty plea will be entered on your behalf. Your next court date will be December the 20th, 2023 for your probable cause conference, and December 27th, 2023 in front of Judge Robbins for your preliminary examination. Before I address bond conditions, can I address the issue of bond, please?
Yes, Your Honor. This defendant was cooperative. He former CPL license holder, no criminal record. So we're asking for $10,000.
Okay, so as part of your bond conditions, you're just not to have any weapons during the pendency of this case, as well as any thing that can be used as a weapon, taser, brass knuckles, and so forth. And so your bond will be $10,000 personal. Thank you. Thank you. You can step aside. Care of it. I haven't done anything. No. I'm gonna do it after. Sorry. State your name, please.
Seth Mitchell.
All right, calling case number 23060333701, the people versus Seth Mitchell.
Manually writing for the people, Your Honor.
Driver on PA 3665, we have Mr. Seth Mitchell, we waive the reading, Mr. Mitchell stands mute, he's been advised of his rights.
All right, a not guilty plea will be entered on your behalf. Your next probable cause conference date is December 15th, 2023. And your preliminary examination date will be December 20th, 2023 in front of Judge Sabri. In terms of bond, before I impose bond conditions, counsel?
Yeah, the people are gonna ask for $10,000 personal bond. The defendant, though, was on foot when he was observed by the defense, by the police. He was not cooperative. He lay on the ground. Search him. He was arrested. He's only 20 years old. And we hope that this will be the last time he's involved.
No objection to personal bond, Your Honor. My client doesn't have any prior criminal history. He's gainfully employed as a stable resident in the state. We would ask the court for that personal bond.
Okay, I'm going to impose a $10,000 personal bond. Your conditions, you're not to have any weapons of any kind, no guns, no tasers, no brass knuckles, nothing like that. And I hope that this is your last contact with the system. Step aside. Thank you.
Next man.
State your name, please.
Down with Mont Smith.
Did you say Maxwell? Did you say, state your name again?
Down with Mont Smith.
This is Christina Bridges. Okay. All right, Mr. Smith, you have several other misdemeanor matters that you have failed to handle. And there are warrants in these matters. And so I'm going to set aside the warrants. I'm calling case number, ticket number, actually. Where's the ticket number? 264980. This was for no operator's permit. P11688920. Improperly displayed plate, improper plates, no insurance misdemeanor. P116197, driving while license not valid or improper license. I'm going to set aside the warrant in these matters enter a not guilty plea for you. And set this for a hearing date of
Disregard the email. Disregard.
January 11th, 2024, in front of Judge Archer. You have the right to remain silent. Anything you say can or will be used against you. If you can't afford an attorney, one will be appointed for you. Do you understand what I've just said to you?
Yes.
Okay. Here. Calling case number 23060333801. Up, wrong, nope. Take that. That's not correct. Wrong case number. I apologize. Those two were put together and these go with that. Excuse me, but his A1 matter. I don't see it. It's not attached to this. This is Jalen. This is somebody else. This is somebody else. Unless I'm missing it, where's his A1 matter? It's tickets, right?
Yeah.
Right.
So what are you looking for?
The matter that he's here for on his,
Felony?
yes.
Your name is, Bonnie.
It's the one with the two people. That one. He's,
This one?
yes,
Oh, it's below it.
He's
Here.
number 2.
Okay. Okay, calling case number 23060333802, the people versus Donnie Lamont Smith.
Judge, good morning. It's a pleasure. Steve Benson for the people, P71917.
Ryan Marab, PA 3665, on behalf of Mr. Donnie Smith, you may be reading. Mr. Smith stands mute. He's been advised of his rights.
All right, so I'm going to enter a not guilty plea on your behalf. You will have a probable cause conference on December 15th, 2023, and a preliminary examination December 27th, 2023, in front of Judge Giles. As for the issue of bond, before I impose bond conditions.
Thank you, Your Honor. Respectfully, we're going to be asking for $1 million. We're also going to be asking if the defendant were to post that $1 million, which we would be asking for cash, monetarization, as well as home confinement. Your Honor, I'm going to tell you the reasons to support the cash, then I'll just briefly get into the allegations. This incident, Judge, and the behavior specifically of this defendant, they clearly show that this defendant is a danger to the multiple complainants. There was only one listed on the investigator's report in terms of identification. There were actually 2 complainants here. Further, it was this defendant who gave an order to the other defendant in this matter to kill the complainants. That order to kill was unsuccessful because the complainant who was shot survived. And Your Honor, as a direct result of that, the people are concerned that based on the fact that that individual stayed alive, that order to kill was unsuccessful, we feel as though those complainants are at a great risk of harm by this particular defendant. And that based on the nature of the offenses, we are requesting that $1 million. He's also a HAB 4 judge. In this particular matter, and Your Honor, I know that the investigative report was quite extensive, but we have a shooting allegedly by this defendant that was motivated as a direct result of this defendant believing that complainant 1 and complainant 2 were informants to the feds. Why? Because his drug house that he was selling drugs from was raided, and he ended up seeing both complainants talking to the police. So as a direct result of that, this allegedly, Judge, was retaliation. As we see in the investigative report, the defendant, as well as an additional defendant, and the individual who subsequently got shot, entered a residence. This defendant, as well as the other defendant, ended up tying up the individual they came into the house with, who was complainant 1, as well as complainant 2, who was the girlfriend of the homeowner. This defendant, with the other defendant, ended up making those 2 individuals that were tied up go down into the basement. This defendant ordered the second defendant to kill the complainants, wherein defendant number 1 ended up shooting complainant number 1. That shot penetrated that complainant's scrotum. Subsequent to the shooting, Judge, this defendant, as well as defendant 2, ended up stealing the homeowner's vehicle. Subsequently, they were arrested, and Judge, multiple people within that residence have positively ID'd this individual as the individual who was at that house who ordered the shooting. Judge, based on the allegations, based on the nature of the offenses, based on the motivation, based on all of the particulars of this case, we feel as though this defendant is a substantial danger, not only to the complainants in this matter, but to the community as a whole. And therefore, Judge, respectfully, we're going to be asking for that $1 million cash bond with monitorization and home confinement.
Your Honor, on behalf of Mr. Smith, I would argue that he's 44 years old. He's been a life resident here in the city of Detroit his whole life, where he has a stable residence with his mother. He has 3 children. He's not employed at this time, Your Honor. He's not able to post any monetary bond, let alone $1 million with a tether as if that we can do anything. Judge, with regard to Mr. Smith and some of the allegations that were read into the record, I have to argue them. I heard the people mention a lot about order to kill, this order to kill. My client is charged because there's a statement made against him that he made a statement, that he told somebody to shoot somebody, and that the allegations don't say that he tied anybody up. The allegations say that he told people to tie each other up. It's all statements about his statements. That's why Mr. Smith is here today. Statements about his statements. Now, I understand it's an assault with a murder charge. It's a unlawful imprisonment charge. These charges typically, courts do issue high cash bonds, but to issue a bond in anywhere near $1 million is absolutely depriving my client of his right to a reasonable bond. Judge, we talked about identification. Who made these identifications? The complainant and a boyfriend of another complainant? Excuse me.
But they're not. They're saying that we're not, but it says we are.
Yeah. Yeah, says we're lying. Yeah, you're correct.
Thank you.
I'm sorry to interrupt. You're good.
Okay.
So, Judge, I was just going to continue.
Yeah.
No, you're good. Any questions? Okay.
That's the last one.
Okay. I'll be right here. I'll be right there for a few minutes and back upstairs.
Okay.
You need anything?
Thank you. Okay, proceed. I'm sorry.
Thank you, Your Honor. And this isn't the time to litigate this case for this investigative report. We don't have discovery. We don't have anything. We have the police officer side and any witness that the police officers interviewed side. We don't have my client's side, we don't know what happened. But what we do know is if we take all these allegations, no matter what they are, they're statements about my client's statements. It's not my client who's alleged to have shot at. That's not what this case is. That case would warrant a high cash bond. This is a case about a statement that my client may or may not have made, and if he's presumed innocent, and we're not presuming guilt at this stage, we're gonna give this guy $1 million of a bond because of a statement made about his statement stuff. Again, these are serious charges. I get the court has a job to do, it has to protect the community. I understand. So what I'm gonna ask the court to do here, while considering that he has no assault and criminal history, this isn't anything that he's ever getting, no assault convictions that I'm aware of. He's not on any probation or parole. I'm gonna ask the court to consider a reasonable bond because he's not employed, because he has a stable residence. I'm gonna ask the court to consider a GPS confinement as the people requested, but Judge, there's no point in issuing a GPS title if we're gonna give $1 million cash fine. We can't post anywhere near that. Additionally, Your Honor, I'm looking at, some of these prior criminal convictions, and maybe the people will correct me if I'm mistaken. I don't see anything in the last 10 years. I don't see anything at all. So does Mr. Smith deserve a chance to be presumed innocent and get a reasonable bond? I would argue yes. And as for a reasonable bond with GPS title, fine.
And Judge, just if I may really briefly, it's really funny that defense counsel ended up bringing up the prior convictions, which goes towards the motivation here. The defendant owning a drug house, being in fear of the complainant, speaking with the federal agents or police officers. But for this defendant, it could be argued this incident would have never occurred. And quite honestly, Your Honor, if I could have asked for remand, I would have.
And Your Honor, just to respond briefly, sorry. He's not charged with this. He's not, where's the drug house charge? Where's the witness intimidation charge? There's a process for this stuff. There's the probable false finding. He's supposed to do something like that. Why? He said he stole the complainant's car. Why isn't he charged with receiving concealed motor vehicle? We get folks all the time. Why isn't he charged? Let's give him the benefit of his presumption, Your Honor, and give him a reasonable bond. Yes.
Well, okay, the court has listened to the arguments, and these allegations are very, very, very serious. I mean, there are 18 counts here, and we have a victim who's been shot.
Complaining witness, Your Honor.
Complaining witness has been shot, but still no less shot.
Not by my client.
I'm going to impose a $1 million cash bond with a GPS tether. I do determine, I'm sure that this is an unaffordable bond. So counsel, you can address that in front of the chief judge for a redetermination hearing on Monday, December the 11th at 2023 at 9 a.m. I would imagine that based upon your statements that he can't afford this bond, so there are no other conditions at this time.
Thank you.
Thank you. So it's the co-defendant. Oh, she's a female. Yeah, I saw that. So we'll just have to wait for her. I'll put this aside.
Say it again loud. Jalen Demond Miller.
All right, calling case number 230-6034001, the people versus Jalen Miller.
Your Honor, good morning.
Good morning.
Steve Benson for the people.
Right for P3665, Your Honor, I apologize. Okay. Mr. Miller is, Your Honor, right around P3665, we have Mr. Miller waiting for the reading. Mr. Miller stands mute, he's been advised of his rights.
All right, I'm going to enter a not guilty plea on your behalf. Your next court date will be December 20th, 2023 for a probable cause conference, and December 27th, 2023 for a preliminary examination in front of Judge Robbins. In terms of bond conditions, I'm going to require that you refrain from having any handguns, any guns, any type of dangerous weapons, brass knuckles, tasers, and so forth. As to the issue of bond, counsel, you will have a personal bond, 5,000 personal. Thank you. You can step aside.
That's it for the mail, John.
All right, thank you. So now I need to put the.
Or you get money.
You finished?
I heard you. We're not done yet. Just came down to
Judge Ramsey, I'm looking for the females. I'm looking for the females.
Oh, so it's gonna be, you know what?
I had them and
So
now
let's
they're.
just do an invite. Let's do, and so let's first remove the men's side. So we're right here. Yep, right here. We click there and we'll remove them. Yep, remove. Okay, so now invite. And then we're gonna do, you can do, yep, it's already plugged in.
Oh, it's
So,
already there.
yep, just call.
Okay.
They'll pick up.
The interesting thing is, so I don't know how you guys do it. I told her I have to do it afterwards. So I'm gonna have to just.
Let's just sign it. There's a bunch of signatures. You don't have to write anything. They take care of all that.
I don't think so. I have to write anything.
Oh, you do have to do that. Right. You're right. See if I'm not doing it myself. Don't remember. Yep, click done. Okay, so then you're going to admit. So that is, you must have an MDOC arraignment. Yeah, this is one of the prisons waiting for admission, and this is an attorney. So go ahead and admit them both. I don't know what shot is here on. How long has been up in there? Go ahead and admit him too. Okay. So, all right. Hi. We need a Zoom for the MDOC. Okay. All right. Good morning, Attorney Sharg. What case are you here on?
Good morning, Your Honor. I'm here on Miss Chanella Appling.
Okay, we're just getting to the female side, so she should be coming up shortly.
Thank you.
DDC, can you hear us on the female side? And then, sir, at the MDOC, we're going to get you in a breakout room with an attorney prior to your arraignment. As soon as they join, you'll go into breakout so you can talk with them.
Okay.
Okay. Yeah, so I'll stick here for just a second.
Oh my gosh. Because I gotta clean up my mess. I don't say case number.
It's okay. We don't do it on the weekends when we do arraignments. We don't say case number. What's going on? Nice. All right, MDOC, we're going to mute you momentarily. Okay, here we go. All right, you're going into breakout. Attorney Reagan sending you into breakout room number 1. Why we're echoing today.
All right, Your Honor, grab them right now.
Okay, thank you. Maybe because your volume here is giving you feedback. Yeah. Okay.
So am I with MDOC or Sharg?
So the MDOs, so Sharg is here on one of your females. Where's your list? He's here on Shantae. I believe he's here on Shantae. Maybe. Sound like he said Shantae. We've got a few women. I think so his client will go first. Anyway, because she's on the list first anyway, she should go first. So what's going to happen is you got MDOC and Phil Reagan in a breakout room. Reagan will probably pop back in when they're done, and then you'll just go click on there and close the breakout rooms in order to get your MDOC defendant back into your courtroom.
Okay.
You'll close your breakout room. It's probably a 60-second countdown. I don't know what this computer is set to.
I think I messed up co-defendants.
Okay.
Because it was a he.
Did you make a note of the bonds that you're setting on these?
Oh, yeah.
Okay, you want to give me like your thing and I can start filling out for you.
I don't know if you can read, but I can do it.
You got it?
I know
Okay.
you got to go back.
Okay.
So I just have to.
Yeah,
He's gonna take that all the way off up to 1 o'clock. 'cause he wants to do it. So,
But you're almost done. You're doing great.
but okay.
Because you've got,
Yeah,
you're on
I
your
have
female
that.
side. You got 1, 2, right? 1, 2, 3,
That should be, I think, it.
4. Oh, you got a few women
No,
today.
this was a guy.
Okay. Then you got Shantae,
Mhm.
1, Kyra's 2, Chanel's 3, Christina 4.
Oh, yeah.
I don't know about that person.
Yeah. 5.
Shoot, 4 or 5. Okay.
Put this back. I think I messed up a Friday. Where is the girl? This one. I think she has. She has the tickets. See, hers got mixed in with Bonnie Smith. To put them together.
Female stuff. What's your name, ma'am?
Chanel Appling.
Okay. Mr. Sharg, is this your client?
Yes, Your Honor, it's my client.
Okay, thank you. All right. Chanel Appling, number 4. Mr. Sharg, could you provide your P number for the courts, please, for the clerk?
Absolutely. 43732.
Okay, so, all right, so now you're on Ms. Appling.
This needs to go back.
Run into this, and it happens to me all the time too. We've got files coming from different places.
All right, calling case number 230-592-4101, the people versus Chanel Appling.
Good afternoon,
Counsel,
good afternoon, Your Honor. Stephen Sharg on behalf of Ms. Epling. We'll wait for a reading of the warrant and stand mute to the charges.
Okay, a not guilty plea will be entered on your client's behalf. The next day for a probable cause conference will be December 15th, 2023, and the preliminary examination date will be December 20th, 2023 in front of Judge Sabri.
Thank you, Judge.
Thank you. As for the issue of bond, I will give my bond conditions after. Can I hear from the people, please?
Judge Steve Vincent for the people, I believe this is an attorney general case. And seeing as though it's an attorney general case, the people are not going to be standing in to make an argument.
Okay.
The defense counsel will be on his own to create a good cause argument for any type of argument.
Counsel?
Yes, Your Honor. My client is 45 years old. She's a lifetime resident of this area. She is self-employed and she is not on probation or parole at this time. Respectfully asking for a personal bond.
I'm going to enter a $10,000 personal bond in this matter.
Thank you, Judge.
You're all set. Thank you.
Thank you.
Thank you. And what's your name?
Shantae Marie.
All right, calling case number 220-5582301. People versus Shantae Mikel, is it Mikel? Reese?
Yes. Yes.
Counsel?
Judge, it's a pleasure. Steve Vincent for the people.
Brian Marat, PA 3665, on behalf of Mr. Reese, who waives the formal reading. Ms. Reese stands mute. She's been advised to the right.
All right, I'm entering a not guilty plea on your behalf. Your next court date will be December the 15th, 2023 for your probable cause conference, and December 27th, 2023 for your preliminary examination in front of Judge Giles.
Okay.
As for the issue of bond, counsel,
Thank you, Judge. Per the agreement that this court entered into, we have to establish either that this defendant would be a danger and or a flight risk to this court in order to properly address request for cash bond. We have neither here, Judge. To be charged as an NDOP, there were some threats, Judge, a little bit concerning in the fact that allegedly the defendant was using his car or her car, I'm sorry, Judge, in order to strike the complainant's vehicle. However, with that being said, Judge, it's over a 3-year-old case. And I personally didn't find anything else on this defendant in terms of any criminal allegations and or convictions. Therefore, Judge, I'm going to be not objecting to a personal bond.
Launch is the appropriate here, as people said, non-subject case, non-subject charge. She's gainfully employed, she's a life resident here, understands they have no contact with the complainant with them. Pretty old matter, but Judge took about 2 years to charge her as a personal bond.
all right, Ms. Reese, you're to refrain from having any contact with the complainant. No direct contact, no social media contact, no third-party contact. This court is going to enter a $10,000 personal bond.
Thank you.
Thank you.
Thank you. You're all set.
Thank you.
Thank you. What's your name, ma'am?
Christina Carr. Oh, Christina Bridges is on there. I'm sorry.
Which, is it Christina Bridges or is it Christina? What's your
It's
last name?
Christina Bridges. At the time of the offense, or whatever happened, it was Christina Bridges.
Your Honor, I believe the complaint addresses that with the AKA.
Okay. All right, calling case number 1005701-001, the People versus Christina, is it Janae Bridges?
Yes.
Counsel?
Thank you again, Judge. For the record, Steve Vincent for the people.
Brian Marat, PA 3665, on behalf of Ms. Bridges, who waived the formal reading. Ms. Bridges stands mute. She's been advised of her rights.
Ms. Bridges, a not guilty plea will be entered on your behalf. Your next court date will be December the 15th, 2023 for a probable cause conference, and December 27th, 2023 for a preliminary examination in front of Judge Jefferson. As for the issue of bond, counsel,
No objection.
the court will enter a $5,000 personal bond on your behalf. You're all set. Thank you.
Thank you.
State your name for the record.
Kyra Powell.
Okay. Defense counsel is in the waiting room. Which defendant is he?
The MPOC, Kirk Myers. I don't know.
Oh, so that was the add-on?
No, that's not an add-on. That's number one. He's at another jail.
Okay, so once I get to the female, that's fine. Calling case number 230-5955101, the People versus Kyra Brandy Powell. Counsel?
Thanks, Judge. Good morning, Steve Vincent for the
Brian Marat, PA 3665, and if I recall, the way the reading is called stands deep, she's been advised of the right.
A not guilty plea has been entered on your behalf, Ms. Powell. Your next court dates will be December the 15th, 2023 for a probable cause conference, and December 27th, 2023 for a preliminary examination in front of Judge Jefferson. As for the issue of bond, counsel?
Judge, this is kind of a tough one. We have a mother and a daughter. The daughter lives in the upstairs of a two-family flat. The mom's in the downstairs. Apparently, defendant daughter had some people over, getting kind of loud. Mom didn't want, the loudness to continue. You can see the incident time. It was close to 2 o'clock in the morning. And defendant daughter, to try to resolve mom's issues, allegedly assaults mom. Mom's about 75 years old. Now, Your Honor, with that being said, the matter is about 4.5 months old. I don't have any priors on this individual, and I don't have anything since this incident. Unfortunate, yeah, that a defendant daughter could allegedly do something like this to her mom. However, because of the fact nothing ended up transpiring following this incident, we wouldn't be objecting to a personal bond, albeit, Judge, maybe just a higher personal bond, just to put any judge on notice from here on in, that it's a higher personal bond, maybe making it a red flag. And that in any other conditions Your Honor wants to put onto it, I think the people would agree.
Your Honor, on behalf of Ms. Powell, the type of person Ms. Powell is she's a 44-year-old white resident with no priors, who took her mother out of the nursing home. She cares for her mother. We don't believe these allegations have any merit. The report even says the officers didn't observe any issues. Personal bond would be more than appropriate here. And one step further, I'm going to ask the court to no assault contract with the claimant's best interest as my client. So, you're the only person who's familiar with my client thinks that personal bond.
So this court is very familiar with the issue of dementia. However, we have to keep in mind that individuals with dementia also have lucid moments. Again, these are allegations. Your client is innocent until proven guilty. However, under the circumstances, my concern is the defendant, your client, lives upstairs, correct? And the mother's downstairs. So my question is, does she have anywhere else to go while this case proceeds? Because that poses a problem for me.
It's going to depend on her violence, which will make it better. But if the court issues inclined to issue a no contest, both of those laws, the detriment.
But she can't have contact with the complaining witness anyway. So in terms of caring, somebody else is going to have to care for her. So my question is, does she have full-time employment?
Yes. Well, she thinks she may have lost her job because of this. She has been held missing work yesterday, missing work today, but she's a security guard.
So in terms of bond conditions, I'm going to not allow the defendant to go to that location and to have no contact with her mother, the complainant Dorothy Powell. If she needs a police escort to go and get some things, then the court will allow that. I'm going to impose a $10,000 personal bond. And also a GPS tether allowing for her to work if in fact she has work.
So is there any reason for a GPS tether as she has no criminal history or previous history? Understands that the civil order has never been in trouble and really disputing these allegations?
My concern is actually the complainant in this issue because of the fact that she has dementia. She wouldn't be able to, potentially, if she's not lucid, she's not going to be able to tell you whether or not the defendant was there. And I don't want her to have any contact.
We want to have a good relationship.
If I may, Judge, you know, I think it's kind of ironic, the defense counsel continues to stress the fact that she takes care of her mother. If this is the way that she takes care of her mother, the people solely support Your Honor's decision for a tether in this matter. This isn't a way to take care of a mother who has dementia, allegedly beating on her with different types of objects.
So let me just, I'm gonna stop this right here because of the fact that we know that these are allegations, but again, the court takes it seriously with a person with dementia who doesn't have necessarily the same ability to convey things that have transpired like someone else who doesn't have the impairment. So with that, I am going to impose a GPS tether for work only. Thank you.
They lie. They lie. They lie all the time.
What was the dollar amount they put on there?
$10,000 personal.
All right.
Come on, man.
She know what I have on stage. She know what my job. She know what I have.
Hold on, man. Just get a Pepsi right there.
This is the last one. All right, ma'am, state your name for the record, please.
Ramsey-Heath, Civil Code.
All right, calling case number 230-6033801. The People versus Bianca. Again, I don't want to slay this, but Vukovic. Thank you. Appearances, please.
Thank you, Judge. Good morning. Steve Vincent for the People, P71917.
Good morning, Your Honor. Ryan Barad, PA 3665. On behalf of the defendant, this supports it. We waive the formal reading. Stand mute. Mr. Colesburg has been advised of the rights.
Okay, a not guilty plea will be entered on your behalf. Your next court date will be December the 15th, 2023 for your probable cause conference. And the following court date will be December the 27th, 2023 for your preliminary exam, both in front of Judge Giles. As for the issue of bond, counsel, before I impose bond conditions.
Thank you, Judge.
If there are.
Your Honor's aware of this situation. This is defendant number one in the two defendant case regarding the shooting of an individual. Now we have the shooter. This is the individual, when told to shoot, to kill, she ends up allegedly pulling the trigger. She is an individual, Judge, that was with defendant two the entire time. It may have been defendant two, allegedly, Judge, who had the motivation, but it was defendant one who proverbially executed that motivation, Judge. In addition to the fact that she has that half-second notice, Your Honor, we also have this defendant, which we feel the half notice is incorrect. We have an additional felony matter regarding this defendant, as well as, ironically, a misdemeanor controlled substance maintaining a drug house that she ended up pleading to, in addition to another controlled substance. In my view, Judge, this incident ended up, the motivation was talked about based on drugs and drug houses and the complainants talking to the feds or police regarding some type of interaction that those police had with that drug house. Now, Your Honor, I know I don't have to impress upon Your Honor the dangerousness that this defendant ended up posing in this particular matter, allegedly shooting an individual, that individual subsequently having to go to the hospital and, Your Honor, leaving the incident scene, and she as well She was positively ID. Not just as the individual who came into the house, but the individual who ended up shooting. With all of that being said, Judge, we do feel as though she poses just as grave of a danger to the complainants as defendant number 2, and respectfully, we would be asking for the same $1 million cash bond.
So, Your Honor, I know that, you know, the people in the court rely on this investigator's report, one setting bond. That's what I've been noticing. And as a part of this investigator's report, that was completely neglected by the prosecution. I don't know why it was neglected. I think I do know why it was neglected, because the prosecution wants this defendant to have a high cash bond. But for neglecting the entire report that everybody is basing the bond on the co-defendant for and any bond on any defendant for, that states, if we're taking this as truth that we've been taking, every case, Mr. Norwood's account, he overheard defendant Donnie Smith instructing defendant Kia Vukovic to shoot range or face severe consequences. So why isn't that mentioned? Why are we talking about that? Why is she even charged? I understand if we're gonna give the co-defendant that bond that we gave him and say those things that we said against him, and we're taking that at its word, we're just gonna flip it and turn it, and now she's the shooter. I mean, come on, Judge, $1 million bond, we can't have both. We gotta have one. I'm gonna ask the court to give her a reasonable bond. I'm asking for personal bond with Heather. Yeah, there was a felony conviction for delivering marijuana 5 years ago. I don't have anything since. I know that the people said that there may have been some drug house conviction. I don't have that. She's at Motor City Stamping. She makes $2,400 a month. She's well within the poverty guidelines, including her dependents. Judge, she does have a stable residence with her mother, her father, and her daughter, and her brother. I'm asking the court to give her a reasonable bond, if not personal, which is yes, under her home.
Well, this court has listened to the arguments, and based upon the prior case and the co-defendant, the court believes that the $1 million bond is appropriate in this matter, in addition to a GPS tether in the event that she's able to make that cash bond. And so in the event that you need to address a bond for a redetermination, you can do so on December 11, 2023 in front of the Chief Judge, Judge McConaughey. Thank you.
Thank you.
So I think we just have this one.
All right, John, we're all set?
Yes, thank you.
All right. Bill.
Counsel, have you talked to your client?
Which one, John?
And I think I'm in.
Yes,
Am I in the
Your
breakout room?
No, you're in the
Okay.
you're in the red room. Yeah.
Okay, so are you ready to proceed?
Yes, ma'am.
Okay, let me close you out. No, he's not. He will. Should be out of the breakout room. Okay. Trying to figure out how to close the Mount facility.
Thank you very much, Your Honor.
Thank you. Okay, so. So we're done with the rooms, right? I thought he said he was done with, speaking with him,
Yeah, he was done speaking, but usually.
or you leave it open. What are you saying?
Because we gotta bring, he needs to come back in, the guy at NDOC. Yes, I think this.
Oh, I think-
This is it. He's up in the corner.
Up in which corner? That's the,
He's behind, like on this screen, he's behind your picture.
okay, so how do I get to, okay.
No, we don't need, we don't need BBC or.
I need to get the, other facility on here, right?
Yeah, he's here, he's in the meeting now.
I need to get MDOC, him to join with, let me try to.
We look like we're all here,
Yeah,
y'all.
he's on there. He's.
Oh, so are we,
You probably just can't see him because, see, he's behind your picture,
okay, so are we good?
but yeah.
So I can
We're good.
proceed?
Yes,
Okay,
ma'am.
if we're good. Sorry about that. So this is Kirk Meyer. All right, calling case number 22058092001, the People versus Kirk Myers. Counsel.
Thank you, Judge. Good afternoon, Steve Vincent for the People.
Your Honor, Philip Reagan on behalf of Mr. Kirk Myers, P57156. He waived the formal reading stand mute. He has been advised of his rights.
All right, I'm going to enter a not guilty plea on behalf of Mr. Myers, and his next court date will be December the 21st, 2023, and this for a probable cause conference and a preliminary examination, December the 28th, 2023, in front of Judge King. All right, as for the issue of bond, before I impose bond conditions, counsel, for the People.
Thank you, Judge. I would just like to let you know I have the distinct honor and privilege on a daily basis to argue these bonds with very qualified, highly qualified defense counsel, one of which is Mr. Reagan. And Your Honor, every day I lick my chops if I have the allegations, if I do believe in a case that needs a cash bond, I'm going to go vigorously. I'm going to go adamantly for that cash bond. This isn't one of those cases. I'm going to be asking for a personal bond here. This is an incident allegedly that took place almost 2.5 years ago. There was allegedly a PPO against this defendant with the complaining witness at the time of this offense. But I think Your Honor should know, following this incident, one, that PPO was not renewed. And secondly, this defendant hasn't had any criminal allegations and or convictions brought against him. So with all of that being said and taking it all into account, Judge, I am going to be asking for a personal bond in this matter.
Okay.
And leaving any other conditions up to Your Honor.
Judge, I know this might sound a little bit different, but we're in a day and time when clerical situations happen and we check people's records in terms of what bonds are. And many times, Your Honor, when we look up a person and we see a personal bond, we assume that that person is not in custody. I'm just asking for some type of small cash bond, Judge. So when the clerks do look him up, when they have to order him out, when they have to do a writ, they can know that, you know, hey, he's got a cash bond and maybe we need to look into this. But if it says personal bond in the system, sometimes people think, oh, this person's not in custody. And I just want to avoid that. I'm just asking for some type of nominal bond, whether it be 1,000, 10%, or it's just something nominal. So, you know, it doesn't matter. My client's under sentence for the next 2 years anyway, so he's not going anywhere. So, I'm just asking for something nominal, Judge. I usually don't ask for that, but in this case, I just want to make sure that we don't overlook him. He doesn't get lost in the system, and that we can get him back and rid it out for his court days properly.
Okay, so I see that the complainant, are the parties still married or are they separated, divorced?
Judge, I'm not sure.
Counsel?
It's my understanding that this case relates to the home invasion that he is doing 5 years on. The same complaint, it was around the same time. So I'm not really sure. I just know there's no contact with this person. But when I did speak with my client, this definitely relates to the same case he's locked up for now, Your Honor.
All right, well, I'm just gonna, as bond conditions, have no contact with the complainant, I believe, and to have any direct contact, any indirect contact, third party contact, social media, and so forth.
And Judge, I just do want to reiterate the fact that he didn't have any subsequent, he didn't pick up any subsequent cases following this matter. If it helps, Your Honor, the people aren't going to object if Your Honor wants to issue a nominal cash bond as a direct result of this matter. We don't feel as though this defendant poses a danger. And if that's something defense counsel is requesting, we're not going to object to it.
I've never heard
so
the
this
people
court-
object to a cash bond, Judge, in my life. I've never heard a prosecutor object to a cash bond.
I asked for a personal bond, so I'm staying consistent. You know, I mean, listen, counselor, don't overreach at this point because I'm giving you your request.
All right, so the court will impose $1,000, 10% cash bond.
Thank you very much, Your Honor.
Thank you. All right, this matter is concluded.
Thank you.
Thank you very much, Your Honor.
Can I talk to my lawyer?
I need to put him back in the room.
He'll just left, I don't know if he'll come back.
At this point, his lawyer's gone.
I apologize, but your lawyer is no longer here. I will attempt to try to make contact with him to see if he can get in contact with you. Okay?
Okay,
Because
ma'am,
he's gone. Because he's gone. But let me say this to you. I'm not sure what you want to ask, but anything you say can and could be used against you. So you might not want to say anything unless it's just something procedural in nature.
Yeah, it's
You
just
got a court
procedural in
date
nature,
question?
ma'am. I'm just asking, is the rest of these hearings, is that gonna be in person or I'm still gonna be in Zoom?
So your first, I believe your first probable cause conference date, that's on Zoom. And the preliminary examination is in person.
Okay.
Did that answer your questions?
Yes, ma'am.
Okay, thank you.
Thank you.